I'm Justin Vautier, CEO of Calyx CPA. As most of you are aware, significant development has emerged with the recent success of Trulieve, a large cannabis MSO, amending its tax return and securing a $113 million refund. This event indicates there's a potential pathway for the rest of the cannabis industry to secure refunds by recapturing lost deductions due to 280E. Unfortunately, Trulieve considers its tax position intellectual property and will not disclose its methodology. However, through our independent research and collaboration with other cannabis industry professionals, I believe we understand Trulieve's position and can extend a similar opportunity to the rest of the cannabis industry. The foundation of our argument is based on a nuanced understanding of the evolving legal landscape, highlighted by significant cases and federal actions that suggest a potential reevaluation of cannabis's legal standing. Probably the most notable of these is the Supreme Court case Gonzalez versus Reich decision in 2005. In this case, Reich argued that the federal government is violating the Interstate Commerce Clause of the Constitution, and it should not enforce its regulation on cannabis in states with medical programs, considering medical marijuana is currently an entirely intrastate commerce issue. Unfortunately, at that time, the Supreme Court upheld its broad and more liberal interpretation of the Commerce Clause, reiterating the court's position that the federal government has the right to govern intrastate considerations if the issues such as drug enforcement has broader national implications. However, now that there are 6 conservative Supreme Court justices, support for federal authority over cannabis under the Commerce Clause is being faced with increased scrutiny, most notably with the widespread adoption of medical and recreational marijuana programs by most states. Justice Clarence Thomas acknowledged that the factual basis underpinning the Reich decision has dramatically shifted. This shift challenges the uniform illegality that once supported the federal government's stance. Furthermore, recent court decisions, including the Dobbs versus Jackson case in which the Supreme Court overruled Roe versus Wade, definitely signal a return to a more originalist interpretation of the Constitution, emphasizing state rights and limiting federal authority. This judicial trend, coupled with other legislative actions like the Rohrabacher-Farr Amendment and shifting federal approaches to cannabis regulation, including the Cole Memo and Health and Human Services recommendation to reschedule cannabis, underscores a growing momentum towards recognizing state sovereignty over cannabis regulation. At this point, it's not just a matter of if, but when marijuana will be removed from the Controlled Substances Act and therefore not subject to 280E. Unfortunately, the final decision may take years before the federal government gives cannabis businesses the nod to take action and amend their tax returns to recapture lost deductions. Businesses only have 3 years to amend. After that, statute of limitations run out and they won't be able to file for refunds. So operators in the cannabis space must act now to secure their ability to recapture lost deductions by filing what's called a protective claim for refund. The protective claim for refund keeps the statute of limitation for filing for a refund open beyond the 3 years, automatically granted to all taxpayers. Once again, by filing a protective claim for refund, businesses can safeguard their opportunity to claim possible tax deductions amidst these current uncertainties. At Calyx CPA, we specialize in navigating these complexities. We advocate for our clients and ensure they are positioned to benefit from potential legal shifts like these. I encourage you to reach out today to secure your ability to file for a refund. Until then, we at Calyx CPA have developed a solution to mitigate the impact of 280E to levels as if your business was a legal business. We will continue to save our clients money until this injustice of 280E has been rectified.